What's up, guys? How y'all doing today? Well, baby, if your name is Tony Busby, you have responded to Alex Spiro. And baby, you ain't leave no crumbs. You guys, and what has become a battle of the legal titan egos and everything. Tony Busby has finally broken his silence. And unlike Alex Spiro, right, who is going after Tony Busby, and might I add, he is doing a gosh darn good job at it. Do you know they released this man's drunk driving mugshot? Yes, where he is looking sad, lonely, confused, scared, and calm all at the same time, and looking mighty bloated all at the same time. They got 2 lawsuits from Louisiana, right? And on top of that, they got his ex-sneaky link mistress who said that he publicly assaulted her in a New York bar. Now, here's the thing, right? Tony Busby hit back and said, this is all lies. This is a coordinated effort. He literally got all those people on tape admitting that they work for this girl, Marcy, who's a lawyer, who was bragging about working with Rock Nation, and said it's a coordinated smear campaign. But unlike Alex Spiro, who is doing this novel thing, listen, at the end of the day, I'll say one thing. Is Jay-Z innocent? I don't know. Is his lawyer one of the realest and illest to do it? Absolutely. He is getting his money's worth with Alex Spiro. However, Tony Busby has hit back. We're going to read the letter he said from the court. He basically said that everything that they wrote in these motions are histrionics. It don't make sense. You can't sanction me. This lawsuit will move forward. But Tattletales, really quick before we get into the letter, let me just say this. Y'all need to start checking into the lives. Last Friday, I did a live about the case moving forward. And last Friday, listen, everybody has something to say. And that's good because we invite the discourse, right? But baby, the case we cited as the number 1 case that can move this forward, Pelosa versus the Archdiocese in New York, that it was decided, I believe, in 2021 or 22, the Tony Busby law firm cited that in their letter to the judge as direct evidence that this case could move forward, as direct evidence that this case must move forward under the persuasive argument in the Second Appellate Court of New York. That's right. Before Busby put this in this, and I'm not implying that Busby was watching Tisa Tells live. I am implying, Tattletales, that you heard it here first. And the case law and the reasoning that we cited in that 2-hour live, Tony Busby is citing the same law and the same reasoning. And like we said, and we will stand 10 toes on business, that case is moving forward. And it doesn't matter about the little facts because those can be debated. That case is moving forward. And if Busby hits them with that limited discovery, oh, wait, it's a wrap. But you know what? We'll go on live again tonight to do a victory lap and actually talk about it. Anyway, let's get into Tony Busby's letter. Also, y'all, really quick. I got written up by the Hollywood Reporter. Mama, I did a thing. I got written up by the Hollywood Reporter. The link to the write-up is in the description box. Please go give it a click. Please go give it a read, y'all. I thank y'all so much. And don't forget, whether you're new to the channel or not, we will be doing a 500K celebration. I guarantee is going to blow away any celebration you've ever seen. Anyway, let's get into this letter. All right, let's go. Now, he has accused Alex Spiro of bullying. Let me tell you something. Alex Spiro has been going crazy with, who is he defending? Elon Musk? Is he defending the president yet? Elon Musk, he's Eric Adams, and he got Jay-Z. He is windmilled on people. But when it actually comes to Jay-Z, it looks like he might have actually hit a home run. Let's get into this. Dear Judge Torres, the letter motion filed on December 13, 2024, defendant Sean Carter notified the court of his intention to file a motion to strike him and motion for sanctions immediately under Rules 11C. As with defendant Carter's prior letters filed in this case, it is histrionic in tone, but substantially groundless. Defendant Carter threatens plaintiff with Rule 11 motion based on questions raised by one single television interview concerning events 24 years ago when plaintiff was 13 years old. Defendant Carter also asks this court to alter the federal rules of civil procedure in his favor by abrogating the mandatory 21-day Rule 11 safe harbor period without any legal support or factual justification whatsoever. The former is frivolous and the latter is impermissible. Now, let me just say one thing, right? Two things can be true. Do I believe that this lawsuit will survive? Absolutely. It just needs to be plausible. Plausible just means there is some reality on this earth in the confines of this universe that it could happen. It will honestly survive, especially if they get into limited discovery, push it out till May. Baby, they're going to be free walking. And then when the Diddy case starts, however, is there something really linking Jay-Z to this case? I don't know. I really honestly don't know, because I thought Spiro was going to come out with receipts, but not Spiro. I thought Tony Buzbee was going to come out with receipts, but he has not. And at the end of the day, they are litigating this case in public media. What are you saving the evidence for? Because here's the thing. For people being like, oh my God, he's just going to try it in court. Okay, but you realize this is tainting the jury. If they had more, would they give more? I 100% believe that Diddy was there. However, Alex Spiro did his job. He might have did a little too well, because we will talk about Jay-Z and Diddy not being friends, right? Please, the way Jay-Z roll, Beyonce needs to ask him, well, am I your wife? Do you love me? I just want confirmation. Are we friends? He might hit her with 20 years. We were never friends. Yes, we were married, but it was a business relationship. We were never friends. I'm just saying anyway. Let's get into this, right? Defendant Carter's threat of Rule 11 motion is frivolous because it characterizes one-of-the-mill disputes as fact as proof that plaintiff's complaint is baseless. None of the factual issues Carter identifies are sufficient even to grant summary judgment in Carter's favor, much less support Rule 11 sanctions. The fact that the defendant or a potential witness does not agree or recollect the facts alleged in the complaint does not and cannot give rise to a motion for sanctions for filing a baseless complaint. Defendant Carter's threat of immediate sanctions motion of the first whisper of factual uncertainty is just one more instance of bullying intended to have a chilling effect on plaintiff's counsel, and any more potential plaintiffs watching these proceedings. Again, I 100% agree with that. I 100% agree with that. Rule 11's motion is frivolous on the additional ground that expecting a victim of sexual assault over 2 decades ago, when the victim was a minor and, as her interview revealed, also autistic, to have perfect recall of these facts is outrageous. Defendant Carter twists plaintiff's words when he accuses her, for instance, of guessing at the timing of events alleged in the complaint, such as the length of car rides. But New York courts have expressly acknowledged that plaintiffs in this type of case cannot be expected to have exacting recall and command of relevant facts. I just want to say right now, everybody, for everybody that watched my live and said the case is moving forward, I was the first person to cite Pelusa versus the Roman Catholic Archdiocese. And everybody said it was all crap. And look at Tony Buzbee now putting it in his motion to the court, actually saying effectively what we actually pointed out in the live. We recognize that matters of sexual abuse involving minors, as recounted by survivors years after the facts, dates and times, sometimes approximate and are incapable of calendric exactitude and approving allegations spanning a 4-year window of time in which the abuse could have occurred. They say there's also no basis for Rule 11 motion here, and if filed, such a motion itself would be subject to Rule 11 in response. Of course, we cannot prevent Defendant Carter from wasting the resources of the court and all parties pursuing. However, Carter's requests that the court shorten the filing deadlines for his Rule 11 motion from 21 days to 1 day is entirely improper. Carter fails to cite any precedent whatsoever to support these astonishing requests because there is none. Carter also fails to cite any reason why the federal rules of civil procedure should be abrogated in his favor in this particular case. Again, there is none. The 21-day safe harbor rule exists to provide parties and counsel time to assess the objections being made and to withdraw or modify a pleading or other paper necessary. The safe harbor period has been recognized by the Second Circuit as a strict procedural requirement. It cannot be shortened here because Mr. Carter and his counsel request as such. Whether it's an attempt to play gotcha or to extend additional pressure on plaintiff or for any other reasons. From the outset, Defendant Carter and his counsel have shrilly maintained an entitlement to different rules and faster procedures, from expedited briefing on the issue in anonymity and a summary dismissal of plaintiff's complaint, now a wholesale elimination of a 21-day safe harbor rule. He's basically saying in legal terms, who the F do you think you are? Each instance, the goal has been to blur the facts and rush a decision. But there is aggressive advocacy, and then there is bad faith. Mr. Carter's latest tactics, much like his open threat to refer plaintiff's attorneys for disciplinary action, cross that line. Moreover, outside the courtroom, Mr. Carter has employed tactics and intimidation and harassment even more extreme, torturous, and quite possibly illegal. My firm recently filed a lawsuit in Harris County, Texas, that details how Mr. Carter's company, Rock Nation, and its counsel have bribed my clients to file lawsuits against my firm, threatened former clients, impersonated state officials, and engaged in other behavior far beyond the pale of acceptable conduct. These tactics won't work, and they will be addressed in more detail in connection with the parties briefing the plaintiff's anonymity. Just to let you guys know, I did do a live last night outlining it. And everything, y'all, you need to start tuning in for my lives. I did a live saying how the case could move forward. And I got so much back push. But you said, and baby, look at the actual lawyers citing the case law we dug up, citing the case law that moved the case forward. Coincidence? Maybe. Anyway, let's get into it. Now, I am not implying that Tony Busby watched my live and cited the case law. I am saying that, baby, y'all heard it first before Busby even put it down. So tune into those lives more often. They said, like Mr. Combs, Mr. Carter is rich, famous, and powerful. Mr. Carter will exert all the pressure he can to intimidate and harass plaintiff, me or anyone else. The chilling effect of those efforts is substantial. So, as a potential chilling effect of Rule 11 motion being brought in these circumstances, but ultimately, in our court system, the rules are the same for Mr. Carter and for the plaintiff, and Rule 11 safe harbor cannot be abrogated to his whim. Again, I always thought that was really, that's what you do. That's what you pay a lawyer to do. Alex Spiro is one of the best, and he fiercely advocated for his client, okay? And that's what you do. Finally, Defendant Carter raises the status of my admission in the Southern District of New York. As with his previous letters to the court, his December 13 letter includes a substantial amount of defamatory suggestions about me, including that I am somehow attempting to circumvent the authority of this court to enforce Rule 11 against me. That is nonsense. I'm a member of the State Bar of New York, and I'm admitted to the Eastern District of New York. I intend to apply for the reciprocal admission to the Southern District. The fact that I have signed pleadings and letters filed in this court does not reflect any attempt for me to evade responsibility for anything. To the contrary, I have signed those pleadings and papers because I am the lead counsel in this and other similar cases pending in this district. Respectfully, Anthony G. Buzbee. Y'all, we were waiting for Busby's answer. And we got it. First of all, he is saying, baby, we're going to show who the liar is. I'm admitted to practice law in the state of New York. And we all did say it's something wrong that somebody as big as Busby couldn't practice law and would do something so sloppy. Right? He also cited the case law that, y'all, we cited last week that had YouTube in a flutter when everybody says nothing about Palooza versus the archdiocese, and how that creates a precedence for you can play around with time for 4 years if somebody is a minor, and it set a precedence, a court in state court, but not, I'm sorry, it said it was persuasive from state court to federal court that if someone has cognitive impairment, they also are under the umbrella of Pelusa. If you didn't watch the live, I'll give it to you. It was a man who sued the archdiocese for things that happened, much like Jane Doe, for things that happened 20 years ago. The dates and certain specifics were very vague. The court said you can't expect someone who was a child at that time to actually know what was going on. Okay? Yes, as long as the substantial part is, which is, I know that you raped me. I may not remember the dates or times, but I know it happened. That was enough for the case to move forward. Again, many legal experts that work with this type of gruesome stuff say that it is very common with trauma, childhood trauma, and cognitive impairment for everything to kind of be all over the place, which is why they are the most vulnerable and it's the hardest to try. Again, is Jay-Z guilty? Who knows? But I'll tell you one thing, like we predicted a week ago, last Friday, before anybody said a word, this case will move forward. This case will move forward. Again, we will see what's what, but the case is moving forward. Busby is not down for the count. And yeah, listen, you heard it here first. Let me know what you think in the comments. I'll talk to y'all later. Bye.